Okay, this video we will go over the Exclusive Leasing Management Agreement, which is basically just the management agreement that goes over how we manage and lease your property. You see where it starts off, it discusses that we have to have a written agreement in place before we can start doing anything with your property. Then you'll see your name and our legal name listed, along with the property address and the tax ID, and finally the legal description of the property that the county uses. Then you'll see a discussion of what lease we can enter into with a maximum lease term, a minimum lease term, and the minimum rent, and the date that we can start leasing that property. The term says how long this agreement lasts. Typically it's for 1 year. And you have to provide 60 days prior notice at the end of the contract if you want to terminate. The security deposit will be held in our trust account. This protects you and us along with the tenant, makes the tenant feel much more comfortable about their security deposit being safe. If you have a tenant already in place, when we start managing the property, then obviously this would be different. You would already have the security deposit, but this applies for any security deposit for a new tenant that we place. If you sell the property during the term of a lease, then you agree that we can return the deposit to the tenant. That basically avoids any disputes over the security deposit at closing, which makes it a lot easier. Obviously, you agree that we can collect money from the tenant. Compensation. So all of the different things that we charge are included right here in the contract. We don't have any hidden charges. Everything is disclosed up front. So we'll go through those one by one. Please note that the prices listed here might be very different in your contract. They vary from agreement to agreement based on the price of the house, where it's located, and many other factors. So these are just examples, so we'll just go over what each item means and not the actual amount. The tenant procurement fee, this is the fee that's paid for finding a new tenant. So this is only paid when a brand new tenant is placed in the property. The lease renewal fee is paid whenever the tenant renews a lease. Generally, this is only done once a year. The management fee is just the fee paid for our monthly services of managing the property on your behalf. The late fee, this is the one amount that you'll see here in this contract that doesn't really change. We always split the late fees with the property owner. If you ask us to get a new lease for a tenant that you already have in place, then this is where it discusses that fee. If you ask us to refinance the property on your behalf to deal with the mortgage lender and so on, here is the fee for that. For repairs and maintenance on the property, this discusses our commission on those repairs. Generally, our vendors give us anywhere between a 25 to a 40% discount because of the volume that we do. So you're still coming out well ahead on this commission. But we do like to disclose up front what we're charging on top of the invoice amount. Many other companies just put it into the price and don't let the owner know. We like to be upfront about that, so that's why it's listed here. Also, please note that if you ask us to use a home warranty company, that the amount does increase by 1% on this commission just because of the extra workload involved in that. If you ask us to sell the property to your tenant, for example, this amount is or the commission for that is listed here, along with a discounted commission if the tenant does not have their own real estate agent for the transaction. We're generally a paperless company. We do direct deposits and email delivery of statements. But if you'd prefer to use paper, then there is an additional fee for that, and that's located here. For court appearances, generally this would only be for cases of eviction or for tenants challenging security deposits. In that case, usually the tenant would be paying for that out of their security deposit. But if there is a case where you want us to evict a tenant who was already in place before we started managing the property, and we did not hold a security deposit for that, then you would have to pay the court costs and attorney's fees up front to cover that. And that amount or the range for what that could be is listed here. If you ask us to appear in unrelated court appearances, for example, if you file a lawsuit against a tenant who you believe has stolen some of your property, if you wanted us to appear in court for that, then there's a fee listed here for that appearance. That's pretty unusual, but we have something there just so it's disclosed up front. We generally do one inspection of the interior of the property per year, about 3 months prior to lease renewal. It's a very detailed inspection with about 100 photos that get sent to you. The fee for that's listed here. You can also ask for additional inspections if you'd like. If you ask us to make a trip to the property to do, for example, a personal errand for you, such as picking up a package that was mailed to the wrong property instead of your home, then there's a fee here listed for that. We generally don't rent to Section 8 tenants, but if you specifically request that we do, there is a higher commission for that because of the higher workload dealing with the housing authority and with those tenants, and that fee is listed here. The document processing fee is just a one-time fee when you terminate your management agreement. It basically just deals with all the accounting and everything necessary to get your account closed out. And then there's finally just a catch-all paragraph for if you ask us to do work for you that's unrelated to the management of the property or sale of the property. This paragraph deals with that. It's pretty rare that it comes into play, but we have it here just in case. All funds that we receive from both the tenant and from you are placed into a trust account that's registered with the state. Obviously, you authorize us to debit that account to cover our fees and costs. So if a tenant pays rent, you're authorizing us to deduct from that rent for repairs, for our management fees, and so on. You understand that you have to make or maintain a minimum balance in the trust account. That'll be listed here. And you agree that if it falls below that amount and there's an unpaid bill, that you'll pay that within 30 days. If you don't, there's an unpaid bill administrative charge listed here and an interest in addition to that. We'll provide you a monthly statement listing all income and expenses from your account. If a tenant pays rent up front ahead of time before it's due, then that money is kept in escrow until the rent comes due. We'll issue you a 1099 every year in January for tax purposes. If, and this is a rare instance, but if the tenant were to bounce a check after we had already distributed the money to you, then you authorize us to debit your account to get that money back, just so the trust account doesn't fall into negative territory, which would be against state law. Following a tenant moving out, if there's repairs anticipated that need to be done to bring the property back to rent-ready condition, you authorize us to hold the funds from the security deposit to cover that. Obviously, you authorize us to market the property and to place a lockbox on the property so that tenants can view it. You authorize us to list the property in the multiple listing service for other real estate agents to see. This section just repeats that we're allowed to place a for rent and for lease sign on the property. For repairs and maintenance on the property, you authorize us to get all repairs done that are necessary to keep the property in compliance with state law and the lease. For other issues that aren't required by law, that are cosmetic in nature, for example, there's a limit in the contract listed for how much we're allowed to spend before we have to get your prior approval. So, for example, if the property needed to be painted and it was going to cost $1,500, we would have to get your approval on that because paint isn't required by the law. If there was a repair that was necessary, for example, on a hot water heater, if a water heater broke and that was going to cost $800, that's above the $500, but it's a required repair by law, so we would go ahead and get that done, but of course we would give you notice of that. If you have a home warranty for the property, you have to give us notice of that up front so that we can have that on file in order to make sure that the warranty vendor gets that work. However, you understand that if an item is an emergency, we may not be able to use the home warranty company just because they aren't able to respond quickly enough. You authorize us to hire vendors to do all of this work on your property. You can certainly provide us with vendors that you prefer, and as long as they are fully licensed and insured and do quality work, we'll be happy to use them. You authorize us to have utilities connected and do other work associated with managing the property, such as cleaning it and removing trash. You authorize us to contract with other companies involved in the management of your property, such as accountants, maintenance personnel, attorneys, and so on. You authorize us to institute legal proceedings for evictions, for example, and for any other legal actions that might be involved in the management of your property. And of course, you authorize us to settle those as needed. This is obviously important for evictions so that we can get those resolved. Usually out of court is what we prefer to do, but this gives us the authorization to resolve those issues. You understand that while we'll be showing your property to prospective tenants, that we'll also be showing the property to other, or showing those same tenants to other properties. You understand that we're only subject matter experts on property management and real estate matters. We aren't accountants, attorneys, or other specialists, so for those issues, you should speak to specialists in those areas. We'll make all disclosures required by the law. Specifically about disclosures, you understand that while we do keep your information confidential, if there is information that we're required by law to disclose, for example, defects in the property, we are required to disclose those even if you ask us not to. That is the law. We are your representative in the transactions with the tenants. However, if there was ever a situation where we represented two parties in a transaction, for example, if we represented you in a sale and also the buyer, then we would disclose that to you ahead of time, and that's what dual agency talks about. Designated agency is a somewhat similar situation, and obviously that would also be disclosed to you if that came up. You agree that we are an independent contractor and not an employee. You agree to maintain the property in a habitable and safe condition, complying with all laws and ordinances. Of course, you agree to provide us 2 sets of keys. You agree to maintain insurance coverage on the property. This means a landlord policy, not just a typical homeowner's policy. Make sure you speak to your insurance agent to get your policy converted to a landlord's policy and not just the primary residence policy that you had on it when you were living in the property. You agree to maintain all mortgage obligations, property taxes, HOA fees, and anything else that may be required. You'll ensure that the HOA, the city, or any other authority has not prohibited you from leasing the property. You will not enter the property at any time while a tenant is in possession. This is something that a lot of landlords who are new don't understand, but when you lease a property to a tenant, you no longer have possession of that property. Even though you still own it, the tenant possesses it, and that means you aren't able to enter it. That would be considered trespassing. So we have rules in our leases for how notice has to be given to the tenant, and those are compliant with state laws. So if there's anyone who's going to enter the property, it has to be one of our employees or contractors who's going to do that. Obviously, you won't directly contact the tenant or negotiate anything with them. All that has to be done through us so that there's a single point of contact. You'll agree to maintain any utilities that are your responsibility under the lease. In most cases, this is none. Most leases say that the tenant is responsible, but if there is a situation where the utilities will stay in your name, then you agree that you can't disconnect those, even if the tenant is being evicted. You'll provide us access codes and keys for any gates or other security systems. If there is anything you need to disclose about the property, for example, a defect in the foundation or the roof or anything else, make sure you let us know that ahead of time so that we can disclose to the tenant to keep you in compliance with the law. You understand that we are required to do emergency repairs. Sometimes these will have to be done in the middle of the night, so you might not find out about them till the next day in some circumstances, but that is a part of being a landlord, unfortunately. If a code inspector or some other legal authority states that a repair has to be done, then that is treated as an emergency, and we get that done right away in order to keep you in compliance with the law. If the property is subject to flooding, be sure to let us know that ahead of time so that we can include that in the lease. Any credit reports or other information we collect from the tenant applicants to screen them, that information is confidential and we are not able to release that. So please understand that we can't give you copies of the tenant's credit reports. That information is considered confidential. This agreement could be assigned to another real estate broker. For example, if we sold this company, obviously a pretty unlikely event, but this paragraph does allow for another broker to pick up the contract if that were to happen. If the property was built prior to 1978, then we'll have to provide disclosure to the tenant if there's any knowledge of lead-based paint. So if you have any knowledge of there being lead-based paint in the house, be sure to let us know that so that we can disclose that to the tenant. Obviously, time is of the essence for this agreement. Make sure you get it back to us as quickly as you can. Obviously, you agree to hold us harmless from any lawsuits that arise. This would obviously be covered by your insurance if a tenant sued you for an injury or something, for example, but you agree that we are not responsible for those things, that would be something that you would transfer on to your insurance company. You agree that we can't discriminate against any tenants or anyone else based on race, color, creed, national origin, sex, age, handicap, sexual orientation, familial status, and although it's not listed here, we now include gender identity in that because of how courts may interpret that to relate to sex. So we can't discriminate against anyone on this basis. Do not ask us to. If you do, we may have to terminate the agreement immediately. And this is what the charge would be for that. This is federal and state law, so it's very important that we comply with fair housing laws. You agree that we have to be consistent in our policies, so we can't give special treatment or worse treatment to one of your tenants based on your request. We have to treat all tenants the same under our standard operating procedures. Obviously, the agreement is governed by the law in whatever state the property is located. This one says Georgia, but it could just as easily be Florida if that's where your house is. You agree that this is the entire agreement between us, and there's no oral or verbal agreements or other agreements outside of this agreement. Obviously, we both agree to cooperate and to do everything necessary to get the property rented and well managed. If there's any other exhibits or attachments, they're also considered part of this agreement. Notices should be in writing. You can do those obviously by email, fax, or other means as long as they're in writing. As mentioned earlier, we're required to issue a 1099 to you every year. So we need to have your Social Security number or tax ID. If the property is held in a corporation or an LLC, we have to have that information also, and we'll get to a form here in a second where you fill that information in. Obviously, if you violate the law by refusing to keep the property in habitable condition or something to that effect, we have the right to terminate the agreement. And obviously the standard provisions for waiver of jury trial and attorney's fees and court costs paid by the prevailing party are included. Obviously, we hope that there wouldn't be any legal disagreements between us, but these provisions are included just in case. Of course, the signature page along with our brokerage information. Then there's a premium options where you can select optional programs. For example, you can select a twice yearly inspection instead of once a year. There's a program for property damage, where if a tenant damages your property, you can pay a monthly fee for us to cover the cost of repairing that damage. The cost of that is included here based on how much coverage you would like. There's an eviction protection program, which ensures that we pay any court costs or attorney's fees that aren't covered by the tenant. And then there is a rent collection guarantee program, which states that if the tenant doesn't pay the rent, that we will still pay it to you while we work on collecting it from the tenant. And there's obviously more details included in each of those, so read through those in detail to understand what those programs include. You'll finally fill out a new owner information form. This basically includes all the information for your contact, how you would like payment to be made to you, your banking information, your social security number or employer identification for tax purposes, warranty information for the house, any vendors you would like us to use, and utility information for the property if you have it. And finally, an ACH authorization form that allows us to withdraw the portfolio minimum from your banking account so we can get started on managing the property. That's about it. If you have any questions about any of this, don't hesitate to let us know. Send us an email or go to the knowledge base at help.gtlrealestate.com or give us a call and we'll be happy to answer them.